Welcome to episode 117 of FBI Retired Case File Review with Jerry Williams. I'm a retired agent writing crime fiction inspired by true crime FBI cases. Today we get to speak to retired agent Kevin Rust, who served in the FBI for 29 years. He spent the majority of his career in Mississippi, working out of small resident agencies in the Jackson Division, including 13 years in a one-person office. In this episode, Kevin Rust reviews his investigation of a rural police officer charged and convicted of deprivation of rights under color law violations in connection with the blackjack beating of Jake Gibbs, an elderly black prisoner held in police custody. Gibbs sustained 2 broken ribs as the result of use of excessive force. During his bureau career, Kevin Rust also had assignments in Chicago, Budapest, FBI headquarters, and Quantico. He was a crisis negotiator who responded to many incidents, both domestically and internationally, and taught negotiation concepts to hundreds of state, local, and international officers. Kevin Rust, who prior to entering the FBI was a CPA with Price Waterhouse, currently works as a contractor for the FBI's International Corruption Unit, tracing money flows and identifying for seizure assets that were purchased with money stolen by foreign kleptocrats. You may recognize the name because we spoke to Kevin before in episode 91 when he spoke about another civil rights investigation, the reopened Klan case involving the murder of Ben Chester White. So if you enjoy this episode, and I'm sure you will, and you haven't had the chance to hear episode 91, please check it out. But before we get to the interview, I have to let you know that I have recorded this intro probably 6 to 7 times. I keep starting and stopping and revising and re-recording, and that's because each week it gets harder and harder for me to keep my promise not to do politics on this show. I'm so frustrated and saddened by what is being done to the FBI's reputation. But after spending more than an hour trying to figure out what I want to say, I remembered what I told you before. So, you know what I'm going to do? You guessed it. I'm going to let these case reviews from courageous, hard-working, retired agents speak for me. Now here's the show.
I am excited to invite back again Kevin Rust. Hi, Kevin.
Hi, Jerry. How are you?
I'm doing great. Now, we've talked before about a civil rights case. We talked about Ben Chester White, who was a black man in Mississippi who had been murdered by the Ku Klux Klan, and that case had never been resolved for, 30 years?
Yep, almost 40.
Almost 40 years. But you were assigned to take another look at that case, and you were able to get a successful conviction after all those years. It's a very, very popular episode. I hear from people all the time who really appreciate the work that you did in bringing justice for Mr. White.
Yeah, it was a very rewarding case, and it was nice to be a part of that.
So did you work mostly civil rights cases in your bureau career?
No, I worked a variety because I was in small offices in Mississippi most of my career, but I'd say that I did have a special affinity or desire to work civil rights cases, so I worked a number of them.
All right. Well, that makes sense because we're here today to talk about yet another civil rights investigation that you investigated. I had a chance to read some of the background that you turned into a narrative, and it's a fascinating case. It's a frustrating case. So let's get started. Tell us when you first learned about the police brutality incident.
Okay, Jerry. I first learned about it. I actually graduated from Quantico, and October of 1985. So I was assigned to a small office in Mississippi. This was the Tupelo, Mississippi resident agency. And it was me and one other senior agent there. And a few months later, in early February, I got a call from the head of the NAACP in a small county outside of Tupelo called Tippah County. The head of the NAACP told me about an incident where a 75-year-old man named Jake Gibbs had allegedly been beaten by a police officer. And he asked if I could come up and talk to him and Mr. Gibbs, and I agreed to because, you talked about civil rights cases. Most people, when they think of civil rights, they think of, the class of the stuff I talked about before, Ben Chester White, the Mississippi burning case, the racial violence cases. But another aspect of civil rights cases is police brutality cases. Excessive use of force by police officers during arrests, which many people know we investigate but don't know that it falls under the civil rights umbrella. So I got the call. I went up to meet with Mr. Gibbs. The incident actually happened on a Friday afternoon on February 7th, 1986. Mr. Gibbs had been out driving around, and he admitted that he had been out. He had had a little bit to drink, and he had been driving around, and he rear-ended a woman in a small town called Ripley, Mississippi, just lightly hit her, and he did not stay. He left. He drove off, and a little while later, he came across a police officer. He was a deputy in Tippah County named Willard Butler. Willard Butler pulled over Mr. Gibbs. This is from Mr. Gibbs' story that he told me that first time I met him. And he said, he pulled me over, he put me in the back of the police car, took me down to the Ripley town jail, town police department and jail. It's a very small town in Mississippi, just a very small little police department. And he said when we got down there, he just started hitting me. He said, I don't know why, but he just started hitting me. I kept asking him to stop. And then Mr. Gibbs' memory got a little fuzzy because he said he was just hitting me, and I kept begging for him to stop. And he said finally he stopped, and he said, I remember some woman asking me if I was okay. And eventually he said he spent one night in the jail, and then he was let go the next morning, and then he contacted the local NAACP head. And he had also gone to the doctor and found out that he had sustained broken ribs. So I was a brand new agent, so I didn't really know much about civil rights, police brutality investigations. I knew that experienced agents didn't seem to like these cases, that they were not something that people sought out to work very often in the FBI. And there's a variety of reasons for that. One is that, we work a lot with local law enforcement. We don't like to investigate them unless we have to. Another is that they are very difficult cases to make. They are, I'll talk about that more later. They're incredibly, I learned later in my career that how very difficult it is to make police brutality cases and to obtain convictions and to pursue them successfully. And then the other reason is that these cases are managed very closely by the Department of Justice. There are a lot more rules and regulations in a civil rights investigation than there are in almost any other type of investigation we do. So I would realize that this was my case, and I started looking at our little manual where I would, in fact, it was listed out, what procedures we were to do. We were to interview the victim. We were to obtain a medical release form from the victim. We were to obtain any police records that existed about the incident. And then we were to prepare a report and wait further instructions, basically. We had to get this preliminary report done within 30 days and then wait. So I interviewed Mr. Gibbs, and I found Mr. Gibbs. Mr. Gibbs is a 75-year-old African-American male. He was retired from the railroad. He had worked on the railroad, and he was very small in stature. He had a fringe of white hair. He was unfailingly polite. He called me Captain. That's all he ever called me during the entire association I had with him. I asked him to call me Kevin, Mr. Rust. He just always called me Captain.
Why Captain?
I learned that was because that was what he pretty much referred to every white male in authority as. I think it was from his railroading days, probably. So he called me Captain. But I just really, from the first time I met him, he didn't seem to try and embellish his story. He was just very matter-of-fact about it. He didn't create things. When he said he didn't remember, he seemed to honestly not remember. Plus, he was such a small man in stature, it was hard to imagine needing to strike this man enough. And I could see the bruises, and this was only a few days after the incident, so I could see the bruises on his chest, bruises on his arms, bruises on his legs. I looked at the front of his car. There was only minimal damage that I couldn't really even see on the front of his car. So I thought maybe there's something to this. I didn't really know at that point in my career. I really didn't know any better, but I thought, well, maybe there's something to this. So I went and talked to the doctor. Doctor confirmed he had the broken ribs. I went to notify the police chief because Mr. Gibbs didn't even know that he didn't know the name of the officer. He didn't know. He thought he worked for the town of Ripley because that's where he was taken to jail. So when I went down to the town of Ripley to tell the police chief, one of the things we had to do in our civil rights investigations was notify the head of the law enforcement that we were conducting an investigation. So I went down to notify the chief of police, and he told me no. He goes, that wasn't one of my men. That was a man named Willard Butler, who was a deputy for the Tippah County Sheriff's Office. He said the reason he brought him to the Ripley County Jail was because the hit-and-run accident had occurred in Ripley. So then next I went to the Tippah County Jail, and what we told them at that time was basically that we had a civil rights investigation. We had a complaint against one of his officers, named the officer, and that we would be conducting an investigation, asked for any reports on the incident. The sheriff immediately said, that did not happen. He said that he told me that I know that Mr. Gibbs says that Willard Butler struck him. He goes, that didn't happen. He goes, it's all made up. And I said, okay, we'll investigate it and we'll find out what the truth is. And I said, do you have a report on the use of force by Mr. Butler on the arrest? And he said, no, I don't have any reports. He said that was a town arrest, so that Ripley would have any reports. And the only thing they had was where Willard Butler had sworn out an arrest warrant for Jake Gibbs for hit and run. That was the only records that existed at this incident.
Let me ask you a question. Is it a policy for most police departments that if there is a use of force, for whatever reason, I'm sure when you are trying to arrest some people, there's resistance, and so sometimes the use of force is necessary. But is it a policy that when there is use of force, that be written down or reported someplace?
Yes, almost every department has that policy in effect, and I've seen hundreds in my career. I've seen hundreds of these use of force forms or reports that have been prepared by law enforcement officers and numerous things. Now, this was some time ago. These were small departments, but I was still surprised that there was nothing about the arrest, especially when Mr. Gibbs had sustained real injuries, broken ribs, bruises all over his body. So I did that. I did the arrest checks. Mr. Gibbs had a couple misdemeanor arrests. He didn't have anything major in his background. Obviously, Willard Butler was a deputy. He didn't have any arrests in his background. So I put all this together in that preliminary report, thinking, I wanted to go. I also learned, Mr. Gibbs also told me, or actually the chief of police told me, that there were two other people present during this, or three people present in the police department during the time when Mr. Butler was there with Mr. Gibbs. There was a Town of Ripley police dispatcher. There was a Town of Ripley police officer, a man named Tate Paul. And then there was a third individual that was just visiting and just kind of sitting around talking to the two of them when Mr. Butler came in. Because this was mid-afternoon when this happened. It wasn't late in the evening or anything. So I thought I should go out and talk to those three witnesses immediately, but then I learned from talking to my partner and looking at the manual that no, first I had to get approval from the U.S. Attorney's Office and from the Department of Justice to conduct further investigation. So I had to go ahead and prepare that preliminary report, which I did. I sent off took a while. This was pre-email, pre-fax machines, pre-everything but FedEx. Took a while to get up to Washington, to get to the U.S. Attorney's Office in Oxford, Mississippi. But when it did get to them, it was assigned to two very good prosecutors. I didn't know that at the time. I now know that they're two of the better prosecutors I've ever worked with. One of them was a guy named John Heilman. He was the local prosecutor in Oxford, Mississippi. He was an experienced prosecutor. The other guy was an individual named Floyd Clardy. Floyd was assigned to the United States Department of Justice Civil Rights Division. I talked earlier about how civil rights cases are kind of different, have more regulation than most of the cases. That's something that happened, kind of from the 60s, where they just wanted to make sure that every civil rights case got a good hard look, and that all the T's were crossed and all the I's dotted in the investigation. So there was really a checklist of what you had to do. And the Department of Justice would get these reports, which happened in almost no other investigations that we did, except for the very biggest, most major investigations. Almost, every bank robbery, every white-collar bank fraud was covered by the local U.S. Attorney's Office in Washington. Probably would know very little about it. But the decisions about whether to pursue further had to be approved in Washington and in the local U.S. Attorney's Office. But both of the prosecutors looked at this and said, this looks like there may be something to this. Go ahead and start interviewing the witness. So I was young, naive. I go out and thought I'll talk to the police officer first. He's going to tell me the truth about what happened. And he did. I learned later that's not all that super common in police investigations.
And you're talking about the police officer, the witness, not the deputy.
That's right. Right. Yeah, you're right. Not the subject, the deputy, but the police officer witness. To talk to the witnesses first, and the last thing we would do is talk to the individual, to his subject. So I went out and talked to Mr. Paul. He had been bouncing around law enforcement and other jobs in his career. He seemed like a nice enough guy. We sat down and started talking about that afternoon, and he told me that Butler had walked in with Gibbs. Gibbs was handcuffed at the time, and he said that Butler was just clearly agitated. As soon as he walked in the door, Paul knew him somewhat, didn't know him real well, but knew, small community, he knew him. He said he was clearly very upset, angry. He said that he took the handcuffs off Gibbs, kind of pushed him into a rear interview room / office. And Paul was sitting in a chair where he could see in the door of that office. He said that once they got in the office, Butler pushed Gibbs to the floor, took out a blackjack, and started striking Mr. Gibbs.
There will be some people who don't know what a blackjack is. Could you describe that?
Yes, a blackjack is a leather, in this case there's a few different types, but this one was a leather strap with an iron weight in the end of it. And it was not uncommon to carry one of those back in the late 80s, back in that, but now it's almost unheard of. It's been replaced by batons with police officers. But it was extremely dangerous. It could break bones. Obviously, in this case, it did. And if you hit somebody in the head with it, it could kill somebody because it was a pretty good weight. It got the momentum of swinging that leather strap behind it. So until that point, I had no idea. Mr. Gibbs thought that Butler was hitting him with his fist. He thought that Mr. Butler, and he didn't even know it was Butler, but he thought that the officer was hitting him with his fist. And when Paul said that, I was just kind of shocked because I was like, whoa. I asked Paul, was Gibbs resisting in any way? Was he trying to fight the officer? He said no. He said he was just pushed down. And Paul was very reluctant to say this. He would look down at the ground a lot. I could tell that he was bothered a lot by it. But I was I was impressed at the time, and I was even later more impressed that he just immediately thought this was wrong. I'm going to tell the truth when asked by the FBI, because I've had plenty of police officers subsequent to this that have shaded the truth, outright lied. Some have told the truth, but I've almost never had anyone that told it as readily as Tate Paul did that afternoon when I interviewed him. And I was immediately like, wow, this really, before I was thinking maybe Butler and Gibbs got into some kind of fight. Maybe Gibbs started striking Butler, and he, had to use force to overcome his resistance. But now I had third-party evidence that hadn't happened, that it appeared to be just a straight beating. So I next went to talk to the other two non-law enforcement witnesses that were there, thinking that had been in the office that day, thinking that they would probably confirm exactly what Paul had told me. Unfortunately, it didn't work out quite that way, but first was the dispatcher. She was a white female dispatcher, and I didn't even say this, but Mr. Gibbs, I said, was a black male. Butler was about a 50-year-old white male. And interestingly, in civil rights cases like police brutality, race doesn't matter about whether we charge it as a color of law violation. Doesn't matter if it's a white officer using excessive force on a white person, a white officer using excessive force on a black person, a black officer using excessive force. It's all considered civil rights, color of law investigation. It's basically just use of force by the police, excess use of force by the police. So this woman, I asked her, she was sitting at her desk, which was around the corner. She couldn't see into the office, but it was such a tiny office that I was convinced, I was in that office when I interviewed her. There's just no way she could not have known what was going on right behind her with a thin paneled wall between her. Because what Paul also told me was that Mr. Gibbs kept pleading with Butler, please don't hit me, please stop, please don't hit me. I asked Paul, how many times do you think he struck Mr. Gibbs? And Paul said, I couldn't put a number on it. He said, but it was a bunch. He goes, I kept hoping it would end. And the woman said, so I asked the woman, I said, did you what happened? She said, yes. Mr. Butler came in. Yeah, he seemed a little upset. He said he took Mr. Gibbs into the back room, and I heard a little ruckus. And I was like, a little ruckus? What did the ruckus sound like? Well, it sounded like people were moving around. And I said, did you hear sounds of, Mr. Gibbs being struck? She said, no, I didn't hear anything that I could say was that. And I said, did you hear Mr. Gibbs asking, Mr. Butler to stop hitting him? Oh, no, I definitely didn't hear that. And I was just amazed because, Paul had said all these things happened. Paul was sitting talking to her, actually, a few feet away from her. And he had said all these things happened. She said none of it happened. She said she did hear a ruckus, and that was basically what she stuck with. The third witness was an African-American man who happened to be there, and I'm sure he wished he had come in another time. not that afternoon, but he was sitting there, and so I went to go interview him next. And I also thought, well, he's obviously going to confirm what Mr. Paul said, so now I've got two out of three of my witnesses, and once again, it didn't work out like I thought.
Oh, really?
Yes. When I went and talked to him, he said that he also could not see into the room, but he was sitting on they were sitting at a triangle, Paul, and the dispatcher, and he was kind of sitting next to Paul in a triangle, but from where he was sitting, he did not have a clear view in the room. But he said that what happened is he saw Butler come in. He said Butler seemed a little agitated, took Mr. Gibbs into the back room. And what he said is, he goes, I didn't really hear any sounds that sounded like he was getting hit, but I did hear Mr. Gibbs keep saying, please don't hit me, stop, please don't hit me. I said, did you think he was being hit? And he said, well, I don't know. And all I know is that, did it sound like there was, like someone was hitting someone with a blackjack? I don't know. That, all I know is that what Mr. Gibbs said. I was like, whoa.
Well, that would be a clue that something, if someone says, please stop hitting me, don't hit me, I think most people would assume correctly that someone's being hit.
And I think they would, I don't see how you couldn't hear that sound of someone, if you've ever been near someone being hit. I mean, there's definitely sounds involved. And, it seems like he would have had to have heard that. I think it's kind of, everyone, I think one thing you learn is everyone in the FBI, everyone remembers things differently in traumatic situations. It's definitely true. I mean, and sometimes it's not intentional. Like, he may not have intentionally been trying to not tell the truth, but that's what stuck in his mind. I remember a training exercise we did at Quantico, which always impressed me, which was, we're 20 or 30 FBI trainees wanting to be special agents. And they just showed us this video of a staged bank robbery at the Hogan's Alley there. They just came in, showed us this video. We watched it. Two guys come out of the bank. They run off. They fire a shot at a security guard. They get in the car and they drive off. And what they did is they waited about 5 minutes, and then they came in and said, we want everyone here to write down what you remember about what you saw on that video. So this isn't traumatic for us in any way. It's just, we're watching it. We knew we were watching it for some reason, so we were watching it. So we all wrote down what we remembered about what the two robbers looked like, what the car was, there were a couple bystanders, what they looked like. And then they started comparing notes between the 30 of us, and it was astounding how different our recollections of what we saw were. People would say that the shooter was bald. People would have different clothing descriptions, even different numbers of bystanders, just like incredible difference. So, I think...
And these are people, some of them who already have prior law enforcement backgrounds, but people who believe they have the investigative skills to become agents, and they still got it wrong.
I was amazed at how much I got wrong. I mean, I sat there and wrote down, what I thought each of the guys, because that's what they asked us. What did each of the robbers look like? What's a getaway car? And so I wrote down thinking I had it 100% correct. And then they showed it in slow motion, after they solicited all our answers. And I was like, I probably got 2/3 of it right, maybe. But it was really eye-opening about the way, and this was when no stress, add a ton of stress, probably in many cases, one of the most stressful incidents in somebody's life, just a variety of different memories. So I don't know. I don't think the dispatcher and the visitor were trying to not remember. I don't think. I honestly didn't.
Do you think that the visitor was afraid himself or that there would be police retaliation if he said more?
Yes, I think that may have been part of it. I think that was part of it for the dispatcher. I'll tell you what happened to Tate Paul is that Tate Paul was basically driven out of law enforcement in this small county. No one would talk to him after they learned that he had talked to me and told me that Butler had beaten none of the deputies, none of his co-police officers. He left law enforcement. So it's a very real fear. And yes, I think that probably entered into it. I mean, you can't prove that because these people also went into the grand jury and testified about the dispatcher and the visitor, and Tate Paul all went into the grand jury and testified about it under oath and told basically the same story. So I think there was probably some trepidation on their part to say, to be the person that said that, yes, I heard Mr. Gibbs being beaten. And so I think that may have colored their recollection also. And I learned that in later investigations. That's often true. It's very hard for people connected to law enforcement to testify against an officer. But I now had the 3 witnesses done. So really, this wasn't a very complicated investigation, right? There were 3 witnesses. There was a doctor, there was Gibbs, and there was Butler. Those are really the only people involved, and there were records, some minimal records. So I wrote up those three interviews of the 3 witnesses, sent that to Floyd and John, and they said the next logical step would be to interview Willard Butler. And here, I mean, I'm kind of embarrassed about the way I did this interview, but you got to remember I was 4 months into the Bureau at this point. So I went and interviewed Butler by myself, which is a no-no in the FBI, right? We don't ever interview subjects by ourselves because it's too easy for that person to challenge our recollection of the interview, to say things that what we might have said. But my partner was out of town for a couple weeks. I didn't want to wait because I thought, strike while the iron is hot. And I couldn't very well ask a local police officer to go with me or
No.
to go with me. So what I should have done, obviously, is gotten an agent from Jackson, Mississippi, to go with me. But like I said, I was new, this was all new to me. So I thought, I'll just go interview the guy. I mean, how bad can it be? But it wasn't. So I went and met Butler at the sheriff's office. He walked in. He's a fit 50-year-old guy that he stood up. I was sitting actually in an interview room, and he came in and stood in front of the desk. And I said, well, have a seat. And he said, no, I prefer to stand. I said, well, why don't you have a seat? No, I'll just stand. Now, I thought, this is odd, but I get up, stand up, and start talking to him. And he hands me a typewritten statement. And the typewritten statement says that after he had pulled over Mr. Gibbs, that while he was transporting Mr. Gibbs back to the police department, that Mr. Gibbs had pulled a knife and come over the back seat because he thought because of Mr. Gibbs' age that he wasn't going to handcuff him. And that Gibbs came over the back seat with a knife and attacked Butler. Butler said that I was able to subdue him. I may have struck him. I may have had to strike him during the course of it, but I was able to subdue him, get the knife away from him, and get him handcuffed. He said, I then took him to the police department. I did not strike him at the police department. I just turned him over to the police officer to be put in the holding cell. And that was basically the statement.
But Officer Paul has already given you an interview where he says that Butler did beat Gibbs.
Right. So I'm like saying, okay, well, I read over the statement. This is the second thing I did wrong in the interview. I should have read that statement 3 or 4 times. Instead, I'm standing there reading it while he's standing there across from me, and I read it, and I just start asking him questions. And at first, Butler says, I'm not answering any questions. I'm just going to let the statement stand for itself. And so I said to him, but wait a minute. The officer there, I said, the witnesses there say that you struck him repeatedly with a blackjack. And he said, I'm going to let the statement stand for itself. I said, don't you think that, that you have to respond to that? And he said, the statement says I didn't beat him. I didn't beat him. He goes, I did not strike him at the police department. And he was very stern. I mean, he was very stern. This was one of my first subject interviews. I was doing it alone. And I would have handled this so differently 5 years later.
Now, you're 26. How old is he?
He's 50.
All right, so he's got experience. He's looking at you like, who do you think you are?
Yankee FBI agent. Yeah, yeah, a brand new greenhorn rookie FBI, and Yankee from the north, too. I really got the impression, he was trying to intimidate me, and I didn't have the experience, didn't have the chops. That's why another reason why having another agent along with me would have been pretty good. So I said, do you have the knife that Gibbs used to attack you? And he took it out of his pocket and handed it to me. He said, here it is. And it was a 4-inch long, like folding, not a pocket knife, a little long, bigger than a pocket knife, but a 4-inch knife with a broken tip. And I handled the heck out of that thing. Stupid. I should have, immediately said, sit it down on the desk and gotten a bag and put it in and preserved it for fingerprints. It's a good thing. It's you learn as you go, and sometimes in this job. But I took it into my hand, looked at it, and said, "Okay, thanks." I said, "Do you carry a blackjack?" And he said, "Yes, I do." I said, "Could I see that?" And he held it out, showed it to me, and I looked at it. I should have taken that. I didn't. I said, "Yeah, although that would be kind of problematic since he's denying using it, and there wasn't going to be any evidence on there, but I'd let him put it back onto his belt and kept going." So shortly after that, our interview ended. But I felt okay about it because his and Paul's stories, like you pointed out, were so wildly divergent that I felt like, well, unless he was going to confess, that probably was okay. So we rocked along. Floyd and John both felt, hey, this looks like a case that we can prosecute and we can possibly win because we have the witnesses, we have the injuries. That they were willing to go for an indictment. So first they came down, interviewed Mr. Gibbs, the 3 witnesses, John and I, and Mr. Gibbs told the same story. The witnesses basically told the stories. They put everyone into the grand jury except Mr. Gibbs. And then I was going to testify about what Mr. Gibbs said and then a couple things like what Butler had told me in the grand jury. So I went ahead and did that. We're presenting this now to the grand jury for indictment. And when you present it to the grand jury, the witnesses testify. I was a summary witness. And there are generally 24 grand jurors in a grand jury, in a federal grand jury. 3/4 of them have to vote to indict the individual, or else it's called a no true bill. There's no bill of indictment, no criminal charge if you don't get 3/4 of the grand jurors present. Many times, as you know, Jerry, that's kind of a formality because we have so much evidence, but we weren't sure in this case because it is, it's a police case. There's a racial angle to it. But we still felt pretty confident. They had heard from Tate Paul about this beating, and they had heard from, they'd seen the medical reports of the broken ribs. They had heard the other two witnesses. So we felt pretty confident, but so I left, and John and Floyd stayed in the grand jury, and we're going to ask for the indictment. About 10 minutes later, they call me back in and say, the grand jurors have some questions for you. So I sat down, and it was clear to me from the tone of the questions that they were kind of looking for a reason not to indict. And I can't remember what the questions were, but I was just like, oh, man, some people in this grand jury don't want to indict. And I left.
What was the racial makeup of the grand jury? Do you remember?
I think that generally the makeup of juries down there was probably about 20% African American, 80% white. I think the grand jury, I know there were some African American members of the grand jury, and I think that was generally, what it was. But there were there were a couple people I could just tell were kind of hot. You can read these things when you've done this. Even I hadn't done it often enough, but in retrospect, that they were hostile to the, like saying, well, is it possible that, he was just trying to help, help Mr. Gibbs or something? You don't help people with blackjacks usually. But, so I went back out and I thought, oh boy, this may not happen. So I went back in, and then a few minutes later they asked me to come in for one more question. There was another question that was gave me concern. But then about 10 minutes later, Floyd and John walked out, and they were smiling. And John later told me that they had gotten it by one vote, that they had just gotten the 3/4 that they needed for the indictment. So we didn't arrest Willard Butler. He was a upstanding member of the community, a police officer. We just notified him. He turned himself in to the marshals, was released on his own recognizance, and I was thinking he might plead guilty because we seemed to have pretty good evidence, but he never really considered a guilty plea. And what I also learned, which was just shocking to me, was that this was only a misdemeanor charge. It's a violation of Title 18, Section 242. That's the use of excessive force under color of law. That's why we sometimes call these color of law. And color of law just means legal authority. So, but at that time, unless the person died, it was a misdemeanor. There was not a felony. That law was changed like 4 or 5 years after this incident, where if there was serious bodily injury incurred by the person, then it was a felony. And the broken ribs would make it serious bodily injury. Right, and later I learned that really all you needed was bruises. Just bruises were enough for serious bodily injury. That wasn't enough sometimes for juries, but it was enough for the charge. The Supreme Court later cited, and this and other, this type of case and other cases, a serious bodily injury could just be bruises, basically. But yeah, broken ribs clearly qualify. And so I was just amazed. But they told me, John and Floyd told me that the reason it was a misdemeanor was because when Congress originally passed some of these laws after the Civil War, that they were afraid that grand juries would not indict on felonies of police officers and such. So they had made it where at least they could get the indictment. So we're looking at a maximum for Willard Butler of 1 year in prison for this incident at this time. So he just thought, shoot, I'll roll the dice on it. I'll go to trial. And what's amazing, I later had several police brutality cases, probably 5 or 6 in total. I never had a police officer plead guilty. I think we convicted 4 and 2 were acquitted. And I never had one plead guilty to an officer plead guilty to an excessive force case. Even after the law was changed and made them felonies, they still wanted to roll the dice with a trial? And I'll tell you one incident that just a quick aside. We had a state trooper incident where the guy ran from him. They started kicking him, broke some of his ribs. And he was acquitted. We had good evidence. Once again, we had local police officers who were testifying about it. But what happened in that case was that at closing arguments, 30 state troopers in uniform came into the courtroom and basically looked at the jurors, who all were from small towns in Mississippi and drove on the roads frequently, and they acquitted them. Just basic jury, nullification, but
intimidation.
Yeah, and that's why these cases are so hard, because people want to believe police officers. They want to give police officers the benefit of the doubt, and I do too. And that's why I told one police officer, I said, the guys get the gray areas. It's only when you get over in the black that we get involved. But anyway, so it was just, so I see why that it was a misdemeanor at the time. I'm glad it later got changed to a felony. So we go along getting ready. We're pretty much ready for trial. I think the incident happened in February. He was indicted in September, so that was about 7 months. A lot of that was waiting for those reports to go back and forth to Washington and stuff. And the trial happened in March of 1987. That was my first. This is my first trial as an FBI agent. And first thing we have to serve. We served the witnesses, the doctor. Served them all with subpoenas, but John Heilman, who was a veteran prosecutor, told me that he did not want to serve Mr. Gibbs until right before the trial, because he was afraid Mr. Gibbs might get scared and kind of worry too much about it. So he told me on the Thursday before the trial, go out and serve Mr. Gibbs. So on the Thursday before the trial, I went to Mr. Gibbs' trailer. He lived in a trailer outside of Ripley. And I'd been there a couple times before. It's a nice neat little trailer. He had, had a little heater inside there and had nice shoes. He was kind of a flashy dresser. He had shoes all lined up in there. And I went there, and I get to the trailer, and there's a padlock on the outside and a hasp, and a padlock. The thing is locked from the outside. There's a note on the door saying, I have gone to Tennessee for a few weeks. I don't know when I'll be back. Jake Gibbs. And he knew the trial was coming up. So I'm thinking,
So the trial starts that following Monday?
Right. And I thought, you don't often put notes on your trailer announcing that you're out of town, right? That's not a great home defense strategy. So I thought, this doesn't strike me as right. So I went and knocked on a couple of neighbors' doors, and a couple of women loyally told me, yes, I haven't seen him around. He must have gone to Tennessee. And I'm thinking, oh, my gosh, how am I going to find this guy? Our trial starts Monday. He is our key witness. We have to have a victim. But then there was a young boy walking between a couple of trailers. Inside, he was about 9 or 10. And I asked, here I am in a blazer and suit and blazer in Mississippi in March. And I said, hey, have you seen Mr. Gibbs around? He said, oh, yeah. He goes, he's been coming and going through a back window, because he had that lock on his door, on the outside. So he said he's been coming and going through a back window. And I thought, okay, I know he's inside. So I go, because Mr. Gibbs, I think his car was not parked in front. But I think, oh, he's probably here. He's stashed his car somewhere, and he's probably here. So I went back, knocked on the door. I've met him 3 or 4 times by now. He knows who I am. He calls me Captain, and I'm knocking saying, Mr. Gibbs, it's Kevin Russ of the FBI. Open up. Everything's going to be okay. I knocked for probably 10 minutes, 15 minutes, nothing. I thought I might have seen a curtain move one time, but I wasn't sure. So I thought, oh, this isn't good. So I called John up and said, look, I think he's here, but he won't come to the door, and I can't serve him the subpoena. And so then John introduced me to the material witness warrant. He told me that you can get a warrant for an arrest of a material witness in a case, which Jake Gibbs would qualify as. And I didn't know that. That wasn't taught to us at Quantico, but I was like, really? We can arrest a witness? He said, yeah. He said, what you should, he goes, go away for an hour or two, come back, see if you can get him, and then try again tomorrow morning, because that would have been Friday. And if you can't, then come down here to Oxford and get the warrant, and we'll go in and, you can go into the trailer and look for him. So I thought, oh, this is great. One of my first, I'd done a couple of little arrests, but I thought, oh, great, one of my first arrests is going to be a witness in my case. So I tried again, no answer. went home that night, came back the next morning, told my partner in Tupelo, who was about a great agent, taught me a lot, but told him, hey, I may need you to help me because we may have to arrest my victim. And he was kind of smiling. I'd been filling him in on the case. And it was definitely unusual, especially when you're a year into the bureau. So I go back Friday morning, same thing. I knocked on that door for 10 minutes and went to windows, tapping on them, saying, Mr. Gibbs, it's Kevin Rust. Everything's okay. So I wasn't 100% sure he was there, but it was kind of ridiculous. But then we go down. I go to the the U.S. Attorney's office. I sign out a warrant that I believe that Mr. Gibbs I sign out a affidavit that John Heilman's prepared that I believe that Mr. Gibbs is a material witness to our trial, which begins Monday in Oxford, and would you please issue an arrest warrant for him? And I get an arrest warrant. United States of America versus Jake Gibbs. And I go back up and I meet my partner, and by now it has started just pouring down rain. I mean, like a Mississippi heavy, heavy March rain. And I also knew that early on in his life, Mr. Gibbs had shot a man, that there was a love triangle of sorts. This is like from hearsay. And that he had shot his competitor with a shotgun, hadn't killed him, and was never arrested for it. But because I guess they kind of felt maybe it was somewhat justified. But I thought, boy, I really don't want to get shot by my victim in a case. So Dave Baldwin, who is my partner, and I kind of talk about it. We said, well, what I'll do, Dave and I as I said, I found a long branch, and I said, what I'm going to do is I had a University of Maryland hoodie in my car. I said, I'm going to hang that hoodie on the branch. And Dave was going to, when I asked John Heilman, I said, there's a padlock on the door. What do you recommend for that? He said, you need an Alabama door key. I'm like, what is an Alabama door key? He said, bolt cutters. I said, oh. He goes, go to the police department. He goes, they'll have a pair. So I went to the Oxford Police Department. Sure enough, they had a big old pair of bolt cutters that they lent me to cut this. So I gave Dave the bolt cutters. I'm holding the hoodie out on a stick. It's just pouring rain. I mean, just beating down on everything. And I knock on the door and tell him, Mr. Gibbs, it's Kevin Rust. Please open up. I didn't tell him we were coming in. I just said, please open up. We're not here to harm you or anything. So then we get ready. I have my gun out. I don't know why. I wasn't going to shoot Mr. Gibbs. I can't imagine any world I would have shot him. I probably would have gotten shot first. But Dave cuts the bolt, throws the door open. Nothing happened. The hoodie's just hanging there. So I drop the stick in the hoodie, and I go up the stairs. Since Gibbs knows me, he doesn't know Dave. I go up the couple stairs into the trailer, and first thing I see is the heater is on. So I'm like, good, he's home. But I don't see him. And so I look around the living room, tiny little, not a big trailer, living room, kitchen, bedroom, little hall back to the bedroom. And I go down the hall, still don't see him. Look in the bathroom, still don't see him. Look under the bed, don't see him. I thought, oh my gosh, he didn't go out the back door the back window, because Dave, after he cut the bolt, went around and looked at the back window, so we didn't think he'd gone out. Plus, I think it was kind of sat in a field by itself, so I think we would have seen him. But now I'm thinking, oh my gosh. So I saw, as I'm coming back, I told Dave, I said, I can't find him. And Dave's now in there. He's inside. He goes, he's got to be here. And so I saw a door that I had missed going down the hall. And I opened the door, and there I saw something that sticks with me to this day. I opened that door. I just had a flashlight, and I'm shining a flashlight. There's coats, but down below the coats, I see 2 white socks. And those 2 white socks are just vibrating. They're just shaking back and forth. And I thought, there he is. And I pushed the coats aside. I put my gun in the holster, and I pushed the coats aside. And I see him just cowering in the bottom of the closet. And his socks were the only things that were showing under the coat. And I shined the flashlight up in my face, and I said, Mr. Gibbs, it's Kevin Rust with the FBI. Everything's going to be okay. And he kept saying over and over, please don't kill me. Please don't kill me. Please don't kill me. And he thought, wow. What he later told us is that people in his neighborhood had told him that white men were going to come kill him. so that he couldn't testify in the trial. And that's why he had put the note out on the door, and that's why he was hiding.
And we have to remember, we have to put this in perspective. Even though it's 1986, this is still Mississippi, where things like that happened all the time, especially for somebody who's 75. He remembers when something like that, if a black man had, said something or complained, issued a complaint against a white man, especially a white police officer, there was that expectation that sometime, maybe during the middle of night, that he would be taken out of his home and killed.
Yes. I mean, this was 20 years after Benchester White was taken out of his home and killed. So, and it was, Mr. Gibbs was 55 years old when that happened to Benchester White. So this was all, and he had heard of many lynchings and murders of African Americans. So, I understood, but it's just like, whoa, I hadn't seen anything like that in my life. This is, in my life I grew up in the D.C. suburbs in a kind of sheltered existence, and I was, oh, this is real. I mean, he's, so I helped him out of the closet, and we got him out. We sat him down in his chair by the heater, and Dave got the lights on, and we're, I'm just talking to him, telling him, Mr. Gibbs, everything's gonna be fine. We've got this trial coming up, and you've got, we need you to testify, and you're gonna be okay. The FBI is gonna protect you. And so I thought, he seemed to calm down. I told him, let's pack a bag that you're gonna be gone. You're gonna be gone until Monday, and until the trial. So let's pack a bag. And I'd walked around with him while we packed the bag, and we got some shoes and got a suit. He had a suit, nice suit. We got a suit, and we got his underwear and everything. We got it in a bag. And so finally, we're actually in Dave's car because his was a bigger, more reliable car than what the first office agent got. So got him outside in the rain, got him in the back seat of the car. Dave and I get in the front seat, and we're pulling away.
Where are you taking him?
Well, that's a great question. We'll get to that in a second. we're pulling away, and he looks and he goes, "Well, I guess this is the last time I'll see my old trailer." And I thought, he still thinks we're going to kill him. I said, "No, Mr. Gibbs, we're not going to do anything. You're going to be fine." And he said, "This is going to be the last time I see my old trailer." And I was just I felt so bad. What he must have felt like when I was knocking on his door for 15 minutes, trying to get him to come to the door, the fear he must have felt. So the next question, which this is another rookie FBI agent, Dave hadn't really talked about this either, is what do we do with him? And Dave says, "Well, you arrested him. You got to take him to jail." And I said, "I can't take him to jail. He's my victim." And I said, the Lafayette County Jail in Oxford was not a great place at that time. They built a new one, but at that time it was just an old, 60, who knows how old that jail was. And he goes, "Well, call my supervisor down in Jackson." So we stopped in a strip mall type thing, and there was a pay phone, and I'd run through.
I got to stop you for a second. Are you telling me you really never thought about where you were going to take him, that you were arresting somebody, but you didn't really think ahead of the fact that if you arrest him, he's going to go to jail?
I don't think I got that. It's a sad thing, but I don't think I really thought it out that far. I told you, I was pretty new at this game, and I thought, well, surely there's somewhere we could put him in. I don't know. I mean, because I remember
the material witness suite.
Yeah. I thought at the time, wow. So I went and called up my supervisor in Jackson. He said, "Yeah, you got to put him in jail." And I'm like, I mean, that's not going to make him a great witness for us spending the weekend in jail, right? But I thought, well, I guess I don't have. But then I started talking to Dave, and I said, I can't put him in jail. He's a 75-year-old man. He'll think now that the FBI's out to get him. We came and got him and put him in jail. And I told Dave, I said, I'm not putting him in jail. I mean, this is a decision that I also would not have made 5 years later when I was married and had a kid and a mortgage. But at the time I was single. I told Dave, I said, I'm not putting him in jail. I said, I'm going to get him a motel room. I'm going to stay next to him, and I'm going to do that. Dave kind of said, he said, good for you, but he kind of also said, let's hope nothing goes wrong. I said, I hope not. But what I did is I took him down. We took him down to Oxford. I got 2 rooms at the Holiday Inn in Oxford, and I put him in one, got adjoining rooms, and I got in the other one. And what I did, this is the old college thing, right? I made paper wedges, wedged his door shut, because I did not want him running off because he was afraid of what was going to happen to him. So, I still was talking to him. I wedged the door shut. By this time, it's, like 10 at night, and we got something to eat before we went there. I went and bought him something to eat. And I pulled the mattress off the bed in the second room and laid it right across the open doors between the adjoining rooms, thinking I didn't want him slipping out of my room while I was sleeping, so he'd have to climb over me, and went to sleep. Next morning, we wake up, and I called some of the people from the Tippah County NAACP that I'd met and told them, look, I need you guys to come, if you can, I need you to come down and stay with Mr. Gibbs until Monday for trial. And 2 guys agreed. They came down. They took my room. They said, yeah, we'll keep an eye on him. We'll make sure he's there bright and early Monday morning. And I felt better at that point. And I never did submit those rooms for my voucher to get paid because as far as
I was going to ask you, who's paying for this? Yeah.
I did. As far as my supervisor knew, he was in jail. So I never. Oh,
really?
Yeah, I never told him. No, I didn't think that would be a great high percentage move on my part, that I directly defied something he told me to do. So I just said, oh, well, I'm not putting those in for a reimbursement by the government. So.
And we have to remind everyone that your supervisor is how far away, because you're working out of a 2-man resident agency, a satellite office.
Right. He's 120 miles south, basically. So I don't think he's going to run up and check on Mr. Gibbs. And Dave wasn't going to tell him. Dave was an experienced resident agent. Things were a little looser back in the 80s than they are now, that I could, God did get away. Because I really thought that if I put him in jail, he might be a wreck by Monday morning and not able to testify. Whereas,
were you afraid at all also that if he was in jail and, there was talk among the different police departments that somebody from the Ripley Police Department would pay him a visit? Was that anywhere in your mind?
In my mind, I was more worried about the other inmates, what he in for type thing. I'm here to testify about a police officer getting beat, maybe some white inmates or something, but I just didn't think it was a good situation. But there really, what else was there? There was not, like you said, there was no material witness to put him in. So it worked.
So you improvised.
I improvised. But like I said, I don't think, if I would have done that several years later when I had to have this job, because I don't know that I would have gotten fired, but had he fled that night, had he gotten over me and out the door and been gone, that probably would have been a good situation for me. But it worked out. So the trial begins Monday morning, and they pick a jury, and Mr. Gibbs is our first witness. And I didn't realize at the time, but it was one of the funniest and still one of the most heartwarming witnesses I've ever seen in a trial. Mr. Gibbs got up on the stand, and he basically told the same story that I heard that first day a year earlier in February of '86. He just said what had happened to him, unembellished what he remembered of it, unembellished language, just laid it out under John Heilman asking him the question. And John, usually you would prepare witnesses a lot, and to get ready for a trial, the prosecutors will talk to them several times, kind of go over questions they're going to ask and what they think the defense attorneys might ask. But John thought with Mr. Gibbs that he was just so basically honest that it was probably just best to just say, just please tell us your story again. What happened to you that day? And didn't really, they met with him on Monday morning Floyd and John met with him for 10 minutes on Monday morning. And just said, just tell the truth like you always have and everything will be okay. And so Mr. Gibbs did it, and then the cross-examination began. And we had prepared, the FBI lab had prepared a floor plan, a blueprint of the Ripley Police Department, so we could show where each of the witnesses and Gibbs and Butler had been inside, and we could show the relative size scale. It was a big chart. And all the other witnesses, like the dispatcher and Tate Paul, we had shown the chart and asked them to indicate where everyone was and where Butler and Gibbs had moved and stuff like that. And they had done it no problem because it wasn't very common. There were like 4 rooms on the chart. And it was no bigger than not even a house, not even close to a house size. It was, 4 little offices, what it boils down to. So, but we hadn't shown it to Mr. Gibbs. Same thing. Don't over-rehearse him. He only vaguely remembers what happened in the police department. He's not going to remember that floor plan. So we were sitting next to the witness, but we had never even shown it to Mr. Gibbs. And the defense attorney, first thing he did is he walks up, he takes out a little collapsible pointer, and he hands it to Mr. Gibbs, and he directs Mr. Gibbs' attention to the chart, and he goes, Mr. Heilman and Agent Rust have shown you this chart, right, Mr. Gibbs? And he turns around and looks at it and he goes, I've never seen that in my life. Which was, the jury kind of laughed. And he goes,
and never ask a question you don't know the answer to.
Yeah. So he goes, well, they didn't show you this chart? And he goes, no. He goes, do you know what this chart is? He goes, no. He goes, this is the floor plan of the Ripley Police Department. He goes, do you know which room you were taken to? And he looks at it for a minute. He goes, no. So the defense attorney kind of collapses his pointer and walks away. This was his first question. I just remember this. So then he decided, because what he was trying to show was that we had prepared Mr. Gibbs, that we had kind of coached him and what he should say and, how best to present it. And so then the next thing, when the defense attorney walked back to his seat, he says, Agent Rust took you to the Ripley Police Department, didn't he? And Mr. Gibbs then said, Agent Rust didn't beat me. He did, pointing at Willard Butler. And the jury kind of laughed. It was kind of like laughed, but it was, but because it was so honest. And we hadn't asked him. I think they had asked him. John had asked him to identify Butler, in the courtroom, and he had. But Mr. Gibbs thought that, that the defense attorney was trying to imply that I had done the beating. So Mr. Gibbs, when really the defense attorney was just trying to say that we were coaching him and took him down there and walked him through the whole thing. And he goes, no.
Had you done that? No.
Same reason. His memory of what happened in that police department, all he remembered was getting hit. That's really all he remembered. I don't know if it was the trauma of it, and he remembered what he remembered was he had gotten hit. And there was a woman who I'm sure was the dispatcher that helped him afterwards. And we asked her about that, and she says, well, I just kind of made sure he was okay. And from what? Well, I don't know. From the ruckus. But
okay, from the ruckus.
Yeah,
he tended to the wounds he got in the ruckus that she didn't see.
Yeah, but anyway, so then we thought, well, okay, so this was pretty funny. And not funny, but it was really great for us. And so he kept working on Mr. Gibbs. He was a very good defense attorney. He was he was hired by Mr. Butler, and he's a very well-known defense attorney in Oxford. And it was I've had other cases. He's always well-prepared, professional, and he was doing his best for Mr. Butler. But one thing that they had, and a couple months earlier, I had gotten a call I didn't tell you about, but I had gotten a call from the NAACP, whose name I just can't recall, from the head of the NAACP, and he told me that Mr. Gibbs had told him that a white man had come to his trailer and had given him some beer and had asked questions about the case. So I went out and talked to Mr. Gibbs after I got that call, and I asked Mr. Gibbs, and he pretty much said the same thing. Yeah, this guy came by, he knocked on the door, he had a 6-pack of beer, he said he wanted to ask me a few questions about the case. And I said, well, what'd you tell him? Yeah, I told him the truth. He goes, I told him, what I told you. And I said, okay, well, don't worry about it. Mr. Gibbs obviously bothered him enough that he called the guy from the head of the NAACP. But I said, don't worry about it. I told John and Floyd, and they said, yeah, it was a private investigator for the defense, but there's nothing we can do about it at this point. And we'll see if anything comes up at trial. So then we went ahead and did Mr. Gibbs testified, Tate Paul testified, did a great job. The dispatcher and the visitor testified. The doctor testified. I testified about the Butler stand-up interview, and then we rested our case. And then they started their case. Their first witness was the private investigator. The private investigator says that, yes, he interviewed Mr. Gibbs on such and such a date in Ripley, Mississippi, and he said that he had recorded that interview and that here's what Mr. Gibbs had said. And what he did was point out, he pointed out some minor inconsistencies between what Mr. Gibbs testified about in court, the day before, and what he had said during that interview, a few months earlier. And he just went through. There were just minor inconsistencies. Nothing, like as you and I know, there's always minor inconsistencies, but defense attorneys often try and make a lot of hay with those, which they sometimes can do. But nothing that I was listening to it and thinking nothing here is earth-shattering. Nothing's really shaking the basic story, of what Mr. Gibbs said. And so they turned him over for cross-examination. And this is where I learned that John was a pretty good lawyer, because John walked up to the stand to cross-examine him, and he said, I'm going to direct you to part of your transcript. He goes, what was Mr. Gibbs talking about when he said this? And here's what Gibbs said. He said, this here's my favorite. No, first he asked, I'm sorry, let me go back. First, John Heilman asked the private investigator, did you give Mr. Gibbs any beer before this interview? And the private investigator said, no, I wouldn't do that. No, I didn't give him any beer. And so John just kind of passed on, and then he asked a few more questions, and then he came back to this question. He goes, I want to direct you to this part of the transcript. He says, Mr. Gibbs says here, I don't like to get drunk, show out, or play the fool, but this here is my favorite. And he asked the PI, he goes, what was Mr. Gibbs talking about when he said that? And the private investigator says, I don't know. He goes, was he talking about beer? He goes, because he says, this here is my favorite. I don't like to get drunk, but this here is my favorite. And the PI goes, I don't know. He goes, he must have been talking about beer. It sounds like he's talking about alcohol, right? But you said, and he goes, well, I don't know. So the defense attorney objects and says, look, the tape of this would be the clearest evidence of what Mr. Gibbs said and intended. And it was just about lunchtime, so the judge says, you're right. He goes, we'll listen to the tape after lunch. So he breaks for lunch, and we go down, and John and Floyd and I are listening to the tape. And Gibbs says, I don't like to get drunk, the rest of it. And right after that, you hear the unmistakable of a beer or soda pop being popped.
Oh, wow.
It is absolutely unmistakable. And so we're like, oh, yeah. That's not
caught in the lie.
Yeah, so we got back after lunch.
And it caught in an unnecessary lie.
Yeah, he could have said, yeah, I brought a couple beers, although it was a dry county, but at the time, but it's just something that he didn't think we'd be able to prove. So we go back up after lunch, and he looks like his dog just died. He's sitting on the witness stand. His head's he's looking down. He knows what's coming. And John, we cue up the tape, and John says, now here's where Mr. Gibbs, and here Mr. Gibbs said, and I don't like to get drunk, show out, or play the fool. And the jury, as one, turns and glares at him. I mean, just glares at him. And John asks him, what do you think that was? And he goes, I don't know. He goes, didn't that sound like a beer opening? And he goes, I don't know what that was. He's staring, almost like looking. He won't look up. He won't look at the jurors.
Wow. So
he's kind of totally discredited. And but then John, at the end, John asked him a few more questions. He goes, how much do you get paid? And he said whatever his hourly rate was. And John said, do you get paid whether, Mr. Butler is that based on a acquittal? He goes, no, I get paid the same whether the case goes good or it goes down the tubes. And John said, like maybe this one should. And John then said, withdrawn, as he's walking back, because
nice.
He knew, they were objecting to that. And so then Willard Butler got on the stand. Willard Butler kind of stuck to his typewritten story. He was kind of interesting that he didn't want to appear weak, like Mr. Gibbs was a threat to him, but he did want to say that Mr. Gibbs had attacked him, and it was kind of just came off as kind of flat. He was very monotone. He wasn't passionate. I've seen guys get on the witness stand and kind of talk their way out of convictions by being so engaging, and so especially like con men, and get the jury to actually like them. But Butler just kind of was very wooden and not particularly believable. And So the jury was only out for 2 hours. They convicted. And the interesting thing was it was an all-white jury because the defense had struck any African Americans off the jury. So it was an all-white jury, was out 2 hours and convicted. So now we're ready for sentencing, right? So we figure he's going to get a year in jail, right? He broke the guy's ribs. That's the maximum penalty. We had a trial. He took us to trial. He didn't plead guilty and accept any responsibility.
And that's what you're asking for.
Yeah, this was pre-sentencing guidelines. Now there's sentencing guidelines. This is what judges are, generally stay within those guidelines. But this was pre-sentencing guidelines, totally up to the discretion of the judge. And we went into the sentencing. I didn't even go to the sentencing, but John calls me up and says he sentenced him to 40 days in jail. And I think it was like a biblical sentence, maybe, 40 days and 40 nights. But we were like, whoa, 40 days for breaking a man's ribs and taking, and it wasn't inexpensive for Lloyd Clardy to be flying back and forth to Washington and to impanel a jury and do the whole thing, but he got 40 days in jail. Wow. And I was just, I was like, wow, that's the hardest I've ever worked for. I think it's the only misdemeanor conviction I've ever had in my career. And it's, definitely the hardest I ever worked for a misdemeanor. Because generally, as you know, we don't even look at misdemeanors. It has to be a felony with usually in white-collar cases with substantial money losses.
Did the judge give reasoning or background when he issued the sentence?
Nope. John said he didn't have much to say. He just said that, that he had been convicted. There wasn't a big, there wasn't a big pre-sentence investigation like there is now. He just said he thought that was a fair sentence, what John told me. So,
and this is, of course, change in the rules. So I take it at the time there was parole. Did he serve all 40 nights?
I looked him up in the prison locator, and after that, and I think he may have done the time in a halfway house, and I'm not sure if he did the 40. It wasn't. The good thing was that we thought John would tell me, but now he can never be in law enforcement again. He said.
Yeah, that is a good thing. Absolutely a good thing.
But unfortunately, about 10 years later, Butler tried to get back in, or he did get back in law enforcement. A sheriff hired him, and he applied with the Mississippi standards. There's a law enforcement standards. He applied to have his certification restored. And the Law Enforcement Standards Board denied it. But then a local chancery judge in Tippah County overruled the board and reinstated Butler as a law enforcement officer. It turns out that the Chancery Court judge had the same last name as Butler's defense attorney, but he overruled, and then the Standards Board, with John Heilman kind of, helping them, appealed to the Mississippi Supreme Court, and Butler was then denied. The Chancery judge was overruled. The Supreme Court, Mississippi Supreme Court, ruled that Butler could not be certified as a law enforcement officer, and that. I think I sent you a link to that decision. It's not real. It's kind of interesting reading, but so that was kind of the final footnote. So he was actually a law enforcement officer about a year or two before they came uncertified, but carrying a gun until that came in.
I'll make sure that I put a link to that court ruling in this episode's show notes on jerrywilliams.com.
So that kind of case, I think going into that trailer and just seeing Mr. Gibbs' feet and hearing him say, "Please don't kill me, please don't," made me realize just how important these cases, can be. And this wasn't the biggest case in the history of mankind by any means, but it was just something that afterwards, whenever I got civil rights cases, I would look at them, give them a good hard look, and if I thought that the law enforcement officer had gone well beyond the bounds of, established practice, and that the prosecutors felt that, then we would. But the interesting thing is, I was telling you how hard these cases are. I probably had like probably 10, 15 complaints a year of excess police force, And of those, so that over the 15 years or so, maybe 100 probably. Of those, maybe 120. Of those, only 5 or 6 did we actually take to indictment. The others were all cleared. Were all cleared as couldn't. Sometimes it's we could never prove it. It was the officer and the victim on the side of the road, and the victim didn't have any very serious injuries. Or the victim. Sometimes the victims would have been actively resisting, and sometimes they kind of just didn't like the officer and made it up. So
it sounds like Officer Paul, was it Tate Paul?
Tate Paul.
Yeah, it sounds like he was the hero. And I hate to call him a hero because what he did was tell the truth, but it sounds like in this type of situation, knowing that you're going to be ostracized by your fellow officers, to come forward and speak the truth anyway is heroic and courageous.
And I did not emphasize that enough, but that was, yes. This case, would have never gone where it went without his basic human decency and bravery. And, it never would have happened without him, because he's the reason that, that Butler was in fact convicted, and that Gibbs was able to feel some measure of, that he had gotten justice for what he had been through. And without Paul, that wouldn't have happened. And that was true in just about every police case I've had. Without a police officer, now, a lot of it's on cell phones, but, some things are in cell phones, or there's a lot more security cameras in places like the Ripley.
Or the body cameras.
Yep, body cameras on police officers. But in the cases I had, it was usually either a law enforcement officer or a jail employee or someone that would really just take a stand and say what happened was not right, and I'm gonna speak out. Whereas there might be other people that were present that say, hey, I can't speak out. I'm not going to speak out directly and forcefully against another law enforcement officer.
Well, it sounds like, you have some great stories, and I think one of the things that you said that we kind of brushed over is that, you're a Yankee from the North, but now you still live in Mississippi, right?
Yes. Yeah. I came back here. I was in D.C. until a year ago and moved back down to Mississippi. My wife's from Mississippi, and its reputation is far worse than its reality at this point in life. I mean, it's not a perfect place, but it's got a lot of strong points.
Between this case review and the case review that you did with Ben Chester White, and knowing that you've worked a number of these cases, I think, because I'm always telling people to write a book, that you've got, the beginning of a great book here. Have you ever thought about doing that?
I have thought about it, and I think the two most useful things I think I did in my bureau career, I did a lot of white-collar crime, a lot of bank robberies, a lot of fugitives, but the two things I got the most personal satisfaction from were civil rights investigations and hostage negotiation. I was a crisis negotiator. And I've thought about writing a book focusing specifically on the civil rights matters, just because I think it's a more timely topic. And the negotiation, while interesting, it isn't something that would be a lot of interest to a wider audience. So I've thought about that, and maybe this will encourage me to do it.
Yeah, well, true crime is very popular now, so I definitely would encourage you to do it, because I think these type of stories, there's not a lot of law enforcement true crime stories about civil rights cases, so I think you would do pretty well if you were to.
I don't mean to. I have the utmost respect for local law enforcement officers. They have,
and that came through. I think that came through.
Yeah, they have an incredibly difficult job. I consider their job to be much more difficult than FBI agents' job, because usually as FBI agents, we know what we're getting into if we're getting into a dangerous, semi-dangerous situation. Every day they put their lives on the line, walking into they don't know what. They're walking into a domestic situation where someone whips out a gun and starts shooting. They pull over someone on the road. And it's just, I have the utmost respect and know that their job is very dangerous. It's just like in any profession, there are some people with anger or issues that cause them to do things they shouldn't do, and so I think that it's important that the ones that do step over that line be held accountable.
I agree. So, we did talk a little bit the last time about your background and why you joined the FBI. So I would encourage anyone that's listening to this episode to go back and check out. I got to look it up here, unless you remember what
91.
episode was. Yeah, so definitely go back and check out episode 91. But you have had a chance to think about your career as, you've been preparing for these case reviews and just living your life. So I'm going to give you another opportunity to have the last word, to kind of tell us what you would like to say, about your career, about the FBI.
I think that, I was really blessed to have a career in the FBI. It was interesting. It was rewarding. It was challenging. And I think that what I tried to do throughout was to protect and serve the people, the Constitution, the people of the United States. And I think that despite what some people may hear in the media these days, that's why almost all of us got into the FBI. And that's really what we all strive to do. Yes, we make mistakes. I told you about a lot of the mistakes I made in this case. Mistakes are made, but I think every agent I've ever met or FBI employee that I've ever met really wants to serve the country and the Constitution. And I think when you hear stories like you're featuring, that it really drives that point home, how important it is to us to try and do the right thing.
And that's the end of the interview. There's a photo of Kevin Rust at jerrywilliams.com, as well as a link to the FBI website post on color of law investigations and that Mississippi Supreme Court ruling that Kevin mentioned during the interview. I hope you enjoyed the episode and that you'll share it with your friends, family, and associates. There are social media share buttons at the bottom of the show notes at jerrywilliams.com. And of course, if you're listening to this on a podcast app, you can share the episode directly from your device. And don't forget to subscribe to FBI Retired Case File Review on Apple Podcast or your favorite podcast app, so that every Thursday morning, just like magic, the newest episode will be waiting for you. My recommendation for you this week is not crime fiction. It's true crime, and it's not a book. It's a TV show. Evil Genius on Netflix. It's a 4-part series about Collar Bomb, or the pizza bomber case out of Erie, Pennsylvania. As you may recall, I've interviewed the retired FBI case agent, Jerry Clark, twice. In FBI Retired Case File Review episode 13, Jerry dissects the Collar Bomb case from the very beginning, when they get that first call that the bank's been robbed, to the very end, when Marjorie Dell Armstrong is convicted of orchestrating the crime. And in episode 78, Jerry's on the podcast again, this time to talk about female serial killers, and we spend a long time discussing Marjorie Dell Armstrong. Jerry Clark is featured in the documentary. And even if you've listened to both podcast interviews, there are still fascinating details revealed in the TV series that you've never heard before. And so again, my recommendation for you this week is Evil Genius, the 4-part TV series on the pizza bomber case, streaming now on Netflix. I want to invite you to join my reader team, where once a month I email a digest of the previous month's podcast episodes and my crime fiction recommendations, and I keep you up to date on the FBI and books, TV, and movies. To join my reader team, all you need to do is go to my website, jerrywilliams.com, and sign up when you see the pop-up. When you join my reader team, you'll get the FBI Reading Resource, which is a list of books about the FBI written by some of the FBI agents who have appeared on this podcast. There are crime fiction, true crime, and memoirs. The FBI Reading Resource consists of more than 35 FBI-related books. Of course, my book, Pay to Play, is there. And soon, my new book, Greedy Givers, will be there too. I don't do Patreon, nor do I have ads on this podcast. But if you want to support the show, in addition to joining my reader team, you can pick up a copy of Pay to Play. It's available as an ebook, trade paperback, and audiobook. Our Greedy Givers on June 28th, the second book in my series about temptation, corruption, and redemption, where Special Agent Carrie Wheeler investigates a multi-million-dollar charity Ponzi scheme, a novel inspired by one of my own true crime FBI cases. Thank you. This episode was sponsored by FBIRetired.com, the only online directory made available to the general public featuring retired FBI agents and analysts interested in showcasing their skills to secure business opportunities. I want to thank you for listening, and I hope you come back again for another episode of FBI Retired Case File Review with Jerry Williams. Thank you.